Well, let's talk about the case in general because that was Arbery and we're talking about Wisconsin right now. In the Kyle Rittenhouse case, I think it's pretty significant. Chanley was telling us that the witness for the defense was basically saying, was saying to the prosecutor, you met with me and you were trying to tell me what my testimony should be. I think that's grounds for some type of motion. What are your thoughts?
Ashley, you are correct. The last thing you want from a prosecution perspective is for a witness, an independent witness with the Associated Press, to say that you are trying to coach his or her testimony. And even worse, that's potentially suborning perjury or obstruction of justice. So this is a huge problem. And it goes back to the beginning of the prosecution's case when one of the key witnesses, the journalist from the Daily Caller, testified and essentially supported the defense theory of the case. That's during the prosecution's case. Now the defense starts their case in chief today with another independent witness who really comes out for the defense, says all these things about Rosenbaum, how he was aggressive, he's using racial slurs, threats, expletives, and ultimately that the prosecutor in this case tried to taint his testimony. This was a huge problem for the state today.
A huge problem. Absolutely agree with you. All right, now let me get your opinion on what a lot of viewers are saying, because I tend to be very pragmatic, very rational as a former judge. I hear all the evidence. And so certainly when we're watching these and reporting on them, we're here to talk about the facts and the law. And in this case, listening to a lot of the viewers, a lot of people have watched and said, listen, I really feel like although there were prosecution witnesses, that the defense did such an effective job that they were in essence defense witnesses because of the description and what they were saying about, to your point, Rosenbaum being the aggressor. What's your opinion and your expertise? Do you think that that's happened in this case?
I think it has. And from the beginning, the prosecution, when they're talking about the FBI infrared evidence, I expected that witness, even though that witness was not allowed to be videotaped or audio recorded, I expected this great testimony about how Rittenhouse was chasing after Rosenbaum, where it turns out it wasn't the case, and it was actually Rosenbaum who was following Rittenhouse. So one witness after another. And Ashley, you know me and you've known me for a long time. I'm very pro-prosecution, but the defense has done an outstanding job flipping these prosecution witnesses. They're supporting the defense theory of the case. And in every self-defense case, the conventional wisdom is the defendant has to testify to really perfect that self-defense argument. But here, it's been going so well for the defense that I don't expect the defense to have to put Kyle Rittenhouse on the stand because they've done such a good job with the witnesses so far.
That was one of my burning questions for you, so I'm glad you went there, because I too wondered, are they actually going to put Rittenhouse on the stand? All right.
It helped the defense, and it helped the defense for two reasons. First, before this case, we knew that Rosenbaum was the best victim for the prosecution because he was unarmed, no skateboard, no handgun. Really, we thought that he attacked Rittenhouse with a plastic bat. Now we've heard all this evidence of his aggressive conduct, threats, and so forth. But this particular witness did two key things for the defense. First, during opening statement, the state said that Rosenbaum was shot in the back. And though it was true that that was the fatal shot, this particular witness, the examiner, said those first shots were from the front. That's key. From every officer-involved shooting, you don't want, if you're a defendant, to be shooting someone in the back. Second, this witness also testified that Rosenbaum was making a lunging motion or moving forward when he was shot. And that supports the defense theory that he was trying to grab Rittenhouse's AR-15, something that supports their theory of the case. So again, good witness for the defense, made two very key points there.
Very key points. All right, in the last 30 seconds, here's what I'd like you to explain to us as well. A lot of chatter, again, about the prosecutorial misconduct. How is the court going to determine whether or not this witness saying, prosecutor told me to say this, rises to that level?
I don't think it's going to be anything that's going to cause a mistrial or misconduct. Usually, this is sort of fodder for cross-examination, in my opinion, Judge Ashley. This goes to the weight of the evidence, not the admissibility. I don't think it's going to get anywhere.
All right. Nima.